Viewers, could the Supreme Court of India have done more to recognize the rights of the LGBTQI community? Has it reduced itself to the role of a mere facilitator today? Many activists and campaigners for gay marriage are disappointed today because the Supreme Court has not even accepted that homosexual couples have a right to marry or to even adopt children. They believe that the Supreme Court stance amounts to suggesting that LGBTQI plus individuals are not on the same moral page as the rest of society. They think this is an indictment of their moral universe. Those who oppose the petition, of course, seeking equality under marriage laws for same-sex couples, are today congratulating the Supreme Court for taking the right stand. They claim that the Supreme Court has acted within the constitutional remit by recognizing the limits of judicial review and acknowledging that the matter lies within the domain of Parliament. But before we go any further into this show, here's a quick look at the main takeaways. So viewers, in the main, you had a situation today where 4 justices chose to write out individual orders. And of course, they took an overall stance 3:2. 2 in favor of legalizing gay marriage and 3 against. In the main, this is what the takeaways were. First of all, no fundamental right to marry under the Constitution. It is very, very clear. Second, no tweaking of Special Marriage Act to make it gender neutral, and neither did the Supreme Court listen to any of the petitioners who wanted it scrapped entirely. The majority opinion opposed extending civil union to same-sex couples. The bench concurred on government panel for access to rights for queer community. They said that, look, a panel can come up with something more humane which grants them dignity. The majority opinion opposed adoption rights for same-sex couples too. In fact, listen to the Chief Justice in his own words, listening to how he, of course, came out in support of the same-sex marriage.
Queerness is a natural phenomenon known to India since ancient times. It is not urban or elite. C. There is no universal conception of the institution of marriage, nor is it static. Under Articles 245 and 246 of the Constitution, read with entry 5 of List 3 to the 7th Schedule, it lies within the domain of Parliament and the state legislatures to enact laws recognizing and regulating queer marriage. This court cannot either strike down the constitutional validity of the Special Marriage Act or read words into the Special Marriage Act because of its institutional limitations. This court cannot read words into the provisions of the SMA and provisions of other laws, allied laws, such as the Indian Succession Act and the Hindu Succession Act, because that would amount to judicial legislation. The right to enter into a union cannot be restricted based on sexual orientation. Such a restriction will be violative of Article 15. Thus, this freedom is available to all persons, regardless of gender identity or sexual orientation. The union government, state governments, and governments of union territories shall not discriminate against the freedom of queer persons to enter into union with benefits under law.
As I said, viewers, the CJI's was a minority judgment. Only one other justice on the bench sided with him, 3 others opposed him. Obviously, the rights activists are not very happy listening to what they had to say.
Clearly, one is disappointed, right? The disappointment is not that somehow I at a personal level, thought that even if full marriage equality rights are not given, at least some kind of civil rights would be given, civil unions would be accepted. So it's really sad that even that didn't happen.
Every judge put the onus on the central government and the state government to formulate rules. So if you are in a constituency, please, if you are from the LGBTQI plus people, or you want to show your support to LGBTQI plus people, please go and speak to your elected representative. Tell them that you will vote for them if they stand up for this, and if they don't stand up for that, please vote them down. Let them also know what going against queer love would actually mean.
We have a special marriage act. The petitioners demanded our marriage right in that particular act, but the honorable judges and union government again considered these things in a religious tone.
Clearly, viewers, you've heard those reactions. Some feel that the Supreme Court played the role of a facilitator, took concerns and put them in the ambit of Parliament. Now, history tells us that the Supreme Court has not always respected the doctrine of separation of powers. Here are some examples when it was accused of running roughshod over the principle. On the issue of the ECI appointment matter, the Supreme Court ruling on appointment by President via panel of PM, LOP and CGI, that's what it said. Government says no law via Parliament. Ask SC to show judicial restraint, basically saying that, look, we haven't even come out with this law, you can't promulgate one on our behalf. Article 324, the government said, highlights the role of legislature for election-related laws, and therefore this falls very much within our remit. Then was the issue of, in 2016, of highway liquor ban. You would remember that, viewers. It touched a raw nerve amongst those who were frequenters of bars, etc. The SC banned the sale of liquor within 500 meters of national and state highways. A large number of state governments said that no proof was presented to link liquor sales near highways to accidents, and a number of them criticized the Supreme Court for, in their words, flagrantly breaching separation of powers doctrine. So that happened too. Then in 2015 came the NJAC verdict. The Supreme Court rejected the NJAC Act to empower politicians and civil society to appoint judges. Parliament had decided to go ahead with that. The SC ruling reaffirmed the supremacy of the collegium system. The ruling was criticized for ignoring vested interests of the judges. You remember this very clearly. It became a massive point of contention. In 2005 cash for vote scandal, Lok Sabha Speaker Somnath Chatterjee ignored the Supreme Court notice of expulsion of MPs. He claimed that he was performing his constitutional duty. Chatterjee questioned the authority of the SC of exclusive domain of the Lok Sabha. And of course, viewers, there was also the Visakha guidelines. They were put in place. Of course, it was a very progressive legislation, progressive policy decision. But nonetheless, there were a number of people who raised eyebrows back then.